Good afternoon to those of you on the East Coast, and good morning to those of you on the West Coast. My name is Felix Shipkevich, and I'm honored and humbled to co-host today's webinar titled "The Application of the Telemarketing Sales Rule Sales Rules to Attorneys Within the Debt Settlement Space." I'm co-presenting it with my partner, Jessica Livingston. I'm going to turn over to Jessica to introduce herself.
Thanks, Felix. I'm Jessica Livingston. I'm serving as a partner at Shipkevich Law Firm. I lead the Florida's office. I'm very excited to be able to co-host this presentation with Felix. In the past, I've represented clients in all sorts of different matters, including litigation and transactional matters in the global financial, fintech, different industries, but I'm really happy to be here. Thanks, Felix.
Thanks, Jessica. A little bit about myself, for those of you who don't know, my firm focuses on fintech regulatory work. We provide services to companies throughout the world and in the US from coast to coast. We represent banks, broker-dealers, debt reduction companies, credit counseling companies. We work very closely with regulators on federal and state fronts. In the spring, I teach at Hofstra Law. I teach a course on the policy and business of cryptocurrencies. And overall, if you'd like to meet Jessica and me, I hope you could join us at our firm's third annual regulatory workshop for debt relief industry professionals. We actually have the biggest workshop this year. We are anticipating in excess of 100 people. At least at this point, we already have 100 people who have registered, and in excess of, I think last time I checked was 50 companies. You'll get a chance to meet attorneys at my firm. You'll be able to chat with us, discuss any issues that perhaps are on your mind that's keeping up at night. And most importantly, what we try to do in these regulatory workshops is provide substantive content for the debt relief industry professionals in order for you to be up to date on the important key material issues that affect your business. We generally have company representatives from back ends, front ends, technology companies, bankers. We have investors who are coming to this event. Attorneys, we have a quite significant number of attorneys who are exploring to do business in the space. I would like to learn more. And most importantly, we do have a keynote speaker, which is a key person at the CFPB, Bryce McNitt. He's chief of staff of the, I believe it's the Market Oversight Division, and really an overall nice guy. And you'll be able to hear his thoughts, the Bureau's thoughts on the industry, and you'll be able to ask questions following his keynote presentation on the 7th. So if you didn't register, you should register. This event is coming up. It's just around the corner. Now, let's talk about what we're planning to discuss today. And I'd like to take a few minutes to give a little bit of background, what transpired for me to suggest this topic for this webinar. As for those of you who know me, I typically get ideas from our clients or potential clients, people who I know in the space, and they ask me questions. And they said, hey, this would be a great subject matter to cover. I've been asked to cover the various issues involving legal models. So we have previously done a webinar on that. What we haven't done yet, and it's been in huge demand, particularly by the attorneys who work in this space, is to talk about the legal and regulatory issues involving the telemarketing sales rule. When I came into the space almost about a decade ago, I was very much surprised when I learned that the telemarketing sales rule has prohibition on taking advance fees that is applicable to attorneys. I thought it was very peculiar and very strange because, well, we attorneys are licensed professional on the state level, and We are required to comply with our respective ethics laws and the rules of professional responsibility. And each state has its own set of rules, advisories on the subject matter. And this was the first time that I came across a different body of law other than bankruptcy, and I'll touch upon that in a second, that had a specific restriction on how you collect your fees. Now, the reason I say bankruptcy is because if you are consumer bankruptcy lawyer, you take your fees up front, right? If you do a Chapter 7, you have to do it. Otherwise, you become one of the creditors and your fees get discharged. If you do Chapter 13 as a consumer bankruptcy lawyer, you take initial fee up front, and then you have to get a court approval technically for the remainder of the fees, right? If you're doing corporate bankruptcy, well, generally your fees have to be subject to approval by the courts and the trustee. That's right. And there are no specific caps on what the fees are in corporate bankruptcy, but judges and U.S. trustee could obviously question if the corporate bankruptcy attorney fees, particularly representing the debtor, obviously focusing on debtor, if those fees are excessive. For most part, it's those who are regularly practice corporate bankruptcy, they obviously know what the cap is and they know what judges are comfortable with. But I've seen it from time to time when bankruptcy judges were not amused by the number of billable hours, not the rate, because you actually have to get the rate be approved. But I've seen bankruptcy courts raise a few eyebrows and restrict certain fees for attorneys representing debtors. And again, switching back to the consumer bankruptcy field, as I mentioned in the Chapter 7, attorneys have to take upfront fees. So why, if you're in bankruptcy, are allowed to take upfront fees, you have to take upfront fees. Why, in fact, do you have such a restriction for attorneys to not being able, and whatever those restrictions are, to prohibit taking fees for performing consumer debt reduction, debt settlement services? And obviously, this also applies to credit repair organizations. I mean, to those who are providing credit repair services. I thought to be quite peculiar because there are many attorneys who practice in this space are not aware of TSR upfront fee prohibition. There are those who believe that there's a blanket prohibition. There are those who believe there is no prohibition, and then those who are confused. And so the purpose of today's webinar is to attempt to address some of the ambiguities, address some of the questions that arise during our representation of attorneys, and also some of the questions that attorneys ask us at our events in person. Unfortunately, we won't be able to answer every single question. We won't be able to cover it. It's a very dense subject matter. It is actually a very challenging subject matter. You'll see in a few minutes why. So what are we looking to do today? Today, we're going to discuss the general application of TSR to attorneys. We're going to have a TSR overview of upfront fee prohibition against attorneys in the debt settlement space. Then we'll talk about the debt settlement legal model and attorneys' fees, ethical consideration for attorneys when providing debt settlement services, analysis of potential risks of practicing law within the debt settlement space. And finally, we'll finish with cases alleging unlawful upfront fees to attorneys under TSR. So we have a lot to cover. It's quite a very dense subject matter. And I'm happy to, Jessica and I will be happy to connect with any one of you, us listening right now live or recorded session, offline, to see if you have any follow-up questions. It is a subject matter that is very difficult to cover in 1 hour or 1 hour or less. You probably could easily spend a day discovering the various ethics and questions about also TSR applications and attorneys. So let's move forward to the next slide. And let's start with the very basics. This is actually taken right directly out of a complaint that was filed against a debt settlement company. Doesn't matter to debt settlement company. This basically shows you how this was a complaint filed by the CFPB. And the three key definitions are debt relief service, seller, and telemarketer. And I want to start with these basic key definitions, because we're going to come back to these definitions in our discussion. So a debt relief service is any program or service represented directly by implication to negotiate, settle, or any way alter the terms of payment or other terms of the debt between the person and one of more unsecured creditors or debt collectors, including but not limited to a reduction in the balance, interest, or fees owed by any person to an unsecured creditor or debt collector, right? This is taken directly from TSR. This is taken directly from TSR and is used in the complaint filed by the CFPB. So to recap, right, in layman's terms, the definition of a debt relief service is basically anytime you're looking to negotiate or alter terms of unsecured debt, you're performing a debt relief service. That's pretty much it. Let's not overcomplicate it. Then we have to be mindful of the term called the seller. The seller is any person who, in connection with telemarketing transaction, provides offers to provide or arranges for others to provide goods or services to the consumer in exchange for consideration. And the key word here is telemarketing transactions. We'll talk about the definition of telemarketing on the next slide. But to sum up, seller means anybody who's telemarketing the sales in exchange for consideration, right? That could apply not only to debt settlement companies, it could and often does apply to marketing companies, or as we call them in the debt reduction industry, front ends, because they sell those services. Finally, on this page, you see the definition of telemarketer, right? Telemarketer is any person in connection with telemarketing initiates or receives phone calls to or from another. Yeah, I mean, that applies also to front ends and back ends, to marketing companies and debt settlement companies, because a lot of times they initiate or receive calls from a customer. So these are very, very broad definitions, okay? So keep in mind for the presentation, debt relief service, seller, and telemarketer. Now, let's move on to the most important definition is telemarketing, right? So the purpose of the 2010 amendments to the Telemarketing Sales Rule. Mind you, Telemarketing Sales Rule has existed since the mid-1990s. The key amendments were done in 2010 during the height of the Great Recession. For those of you who are old enough to remember, and I hope everybody who's listening to this is old enough to remember, we had millions and tens of millions of consumers who were stuck with credit card debt they couldn't afford. Well, mind you, we had obviously, housing crash, but that was really at the height when consumers lost their jobs, couldn't make ends meet. And as a result, right, primarily pushed by the Dodd-Frank Act and by Congress, the Telemarketing Sales Rule was adopted by the CFTC in the 2010 amendment. The CFTC defined the word telemarketing as a plan, program, or campaign which is conducted to induce the purchase of goods or services. Let me read that again. It's a plan, program, or campaign which is conducted to induce the purchase of goods and services. Okay, I just read it twice. Nowhere does it say that the definition of a telemarketing in the TSR discusses any type of debt reduction or credit repair or any type of services. It has a very broad definition. And let's now dissect this even further. A plan, a program, a campaign. So the TSR doesn't define what a plan, a program, a campaign is. So what is a plan? So if somebody's selling you, right? If you go back to the previous definition, a seller, right, is selling you a plan, a program, a campaign, does that mean that they automatically come under the four corners of the Telemarketing Sales Rule? Well, not really, and we'll discuss it in a second. But the problem that I have with this definition is that a plan, a program, a campaign is so broad. It doesn't necessarily mean, if you read the plain meaning, a plan, a program, a campaign, it does not necessarily mean a debt settlement program or a credit repair program. It does not, right? There are law firms who provide plans or programs for consumers that have absolutely nothing to do with debt reduction. Absolutely. There are many programs for consumers that have absolutely nothing to do with debt reduction. Absolutely. I mean, I could tell you that there are programs offered by traffic attorneys for those who regularly get speeding violations. There are programs made by, I don't know, real estate lawyers for whatever, those who regularly, for landlords who regularly lease premises. There are programs. I mean, if you look at websites like LegalZoom, I mean, you basically have programs. Even though LegalZoom is not is not a law firm, but you see programs that fall outside of the debt reduction space. So the definition of telemarketing is very, very broad. I'm hoping for those of you who are still here, you're beginning to understand how, very heavy this space is, particularly on the definitions. Now, no general exemption exists for attorneys under TSR, right? This is taken directly from the Federal Trade Commission website. This is their guidance. There's no general exemption from the TSR for attorneys who engage in telemarketing, right? We just discussed the word telemarketing, which, by the way, does not limit anything to debt settlement or debt reduction. It has a very broad definition. There's no general exemption from the TSR for attorneys. Okay, so, all right. So what happens next? Then it says, however, most attorneys are likely to fall outside of the rule for at least two reasons. So before I go into these two reasons, I want you to understand kind of the contradiction made in these two sentences in this advisory. Because the first sentence says there's generally no exemption from TSR, and then you have a sentence that says, but most attorneys are going to fall outside of this rule. And what's interesting is when we speak to attorneys who are in the debt reduction space, they immediately cite us to this very sentence. Most attorneys are likely to fall outside of the rule, right? And then there are two reasons that the FTC provides. The first reason, it says, TSR applies only to providers who use interstate telemarketing. Interstate telemarketing. And we're going to talk about that for quite a while, and Jessica is going to help me dissect that further. So the first is interstate telemarketing. The second is attorneys who meet face-to-face with their customers before signing them up. Now, the face-to-face exemption, we have a webinar on face-to-face exemption. We've covered it extensively. I believe, and I take a very strong position that the face-to-face exemption is a very, very narrow exemption. It is not a broad exemption. You cannot allege that you could send a notary to someone and that lets you fall under the exemption. No, that is not the case. Face-to-face exemption is a very narrow exemption. And we're not going to talk about face-to-face exemption. The face-to-face exemption for attorneys, well, generally in the space, not even the attorneys, was really made so that if you meet with somebody in person, they see you in person, they know that you're not sitting somewhere offshore and potentially could steal their money. But even with those, there's a cooling period, and we don't want to go into this discussion. The first one is the one that a lot of people are very confused about because it says TSR applies only to use interstate telemarketing, right? Interstate meaning crossing between the different states. And let's say you have an attorney who's based in New York, right, where I'm located, and I'm licensed in New York. And so if a person asks me a question, well, Felix, I'm located in upstate New York. I'm located in Binghamton, New York, and my clients are only in New York. Does it mean I could charge upfront fees? And the answer is, well, yes and no. Right, isn't that like the worst thing that you could possibly ever hear a lawyer say? Yeah, there's two sides of each coin. But that's kind of the reality, just because this specific first prong is very difficult to answer. And I think it was pretty poorly drafted in this guidance. That's right. I do admit I think this is poorly drafted because this doesn't say, right? This doesn't say that it has to be specifically a program, a plan. It does have the term telemarketing, but the interstate, well, if somebody finds me online and I have a website, I am located in Binghamton as an example. I'm an attorney I'm not located in Binghamton, but I'm just giving an example. If I'm located in Binghamton and I have a website, my website's probably seen all over the world. So if I have a consumer from another state, from the state of Nebraska, coming in and finding my website because Google optimizes it, right? And they find my website and they contact me. Well, the question is, was that done through the interstate means? And the answer is, yeah, possibly, because everything right now is interstate. In today's world, it is very difficult to say that something's intrastate. So this is what we're going to dissect even further, which is it applies. So it basically says the two reasons it doesn't apply if you do if only providers who use interstate marketing. Okay, so let's move on further. This is part 10, 310 of the telemarketing sales rule. It says the TSR applies to virtually all telemarketing, all, which is kind of wild if you think about this. It applies to all telemarketing, defined to meet a plan, a program, campaign, which is conducted to include the purchase of goods or services or charitable contribution by use of one or more telephones, by which involves more than one interstate call. The purchase of goods and services is not limited to debt reduction, right? It's not. So this begs the question is, why is this definition so broad? Right? We're coming back to the definition of telemarketing. Again, a plan, a program, or campaign which is conducted to induce the purchase of goods or services or charitable contribution by use of one or more telephones, and which involves more than one interstate telephone call. Well, I could tell you today, most people make more than one interstate call. I mean, I think unless you're calling, if you live in the same state with your parents or friends, most other calls you're probably making interstate. In fact, from the participants that I see on this webinar, I mean, almost everybody here is interstate, right? So this then goes further, and this is where I'll ask Jessica to give her thoughts, right? And this is the wrinkle goes further. In general, attorneys who provide bona fide legal services do not utilize a plan or campaign of interstate telephonic communications in order to solicit potential clients to purchase debt relief services, right? So, so in general, this doesn't apply to the lawyers who provide bona fide legal services. And then it says, thus an attorney who makes telephone calls to a client on an individual basis to provide assistance and legal advice generally would not be in telemarketing. Let me read that again. An attorney who makes telephone calls to clients, I'd probably say that every single lawyer that I know in this country makes telephone calls to clients on an individual basis. Yeah, I don't think we overuse robocalls to clients, right? It says individual basis to provide assistance, legal advice would not be engaged in telemarketing. I mean, that pretty much covers every single lawyer that I know. I don't know if you know any lawyer who uses telephone, not on an individual basis, right? And to provide assistance and legal services generally would not be engaged in telemarketing. So Jessica, what do you think about that?
I think that this is poorly drafted. I'm going to have to agree with you. I think that the term clients needs to be clarified. Like, what does it mean, clients? Does it mean prospective clients? Does it mean already existing clients? The term bona fide is also ambiguous, and then it seems to, in the second sentence, thus an attorney who makes telephone calls to clients on an individual basis to provide assistance and legal advice. It seems to try to clarify the term bona fide by stating legal advice, but then it doesn't define or state what is legal advice and whether or not it includes debt settlement services. Do you need to initiate a conversation that has a legal implication before you get into debt settlement services, and then that takes you out of the purview of the rule? I don't know. It's not clear to me.
It's not clear to both of us, right? I mean, we were discussing this in preparation for this, and we were discussing how poorly drafted this is. I mean, I'm quite surprised that over the past 12 years, nobody else really raised an issue that, well, so in order for you to not be engaged in telemarketing, you have to be one who calls clients on an individual basis. Well, that's everybody, right? I mean, Jessica, do you know anybody who does not do it on an individual basis? I mean,
No,
What does
no.
it mean? I mean, it's not like, for those of you attorneys listening to this webinar or recording, oh, no, 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 I don't do it on an individual basis. I just use a robocall to dial all my clients and I speak to them all once. I mean, it's absolutely absurd, right? And then it says to provide assistance and legal advice. So then if you're providing assistance and legal advice, well, that's kind of what you're paid to do, right? I mean, I don't know. Um, last time I checked, my clients don't usually call me because and they receive an invoice from me because they really want to know what kind of weather it is and is it sunny today, right? So it's always going to be legal advice. So then it's not telemarketing. So therefore, you don't have to worry about the plan and everything else. And this is kind of the confusion. I understand I'm kind of harping on this with Jessica, but that's really kind of the legal pool drafting. What makes it very difficult for us as attorneys who know the TSR very well. We work on it on a daily basis. We work with the FTC and the CFPB in the States. And when it comes to representing attorneys, well, this is probably one of the most challenging areas in the space because attorneys want to say, well, can I charge an upfront fee or do I not charge upfront fee? I mean, I could tell you that generally speaking, if my advice is, and obviously this is not legal advice for the person of the webinar, but if you're primarily substantially doing debt settlement and only debt settlement or credit repair, you should not charge upfront fees because you want to be on the safe side. Now, if you want to roll the dice and maybe litigate this, you do have potentially a point to make in case of any regulatory investigation. But if you look at the definition, basically, if you look at these specific carve-outs, they're kind of confusing, right? And then there's also, again, right above it, in general, attorneys who provide bona fide legal services do not utilize a plan, program, or campaign. What does it mean, bona fide legal services? What does it mean, bona fide? I mean, Jessica, have you ever done something that was not a bona fide legal service? What does that mean? What do you think the FTC meant here?
I can only speculate because I couldn't find anything that really defines bona fide legal services. It's legitimate legal services. That begs the question, what is legal? And if I had a client come to me for legal advice, say we discussed like a bankruptcy case, and I start to give legal advice on bankruptcy, and then I go into debt settlement, like is that a bona fide legal service? I don't know. It's not clear. Is it enough to initiate a conversation based on a legal conversation and then move into debt settlement services? Is that enough to get out of the requirements of the TSR? It's not clear here, in my opinion.
No, I think you bring up a good example, right? Imagine you're a consumer bankruptcy lawyer, which represents probably at least 100,000 or so attorneys in the U.S. Um, not everybody's necessarily a consumer bankruptcy lawyer, but sometimes small consumer law firms will do a lot of consumer services like matrimonial work, like bankruptcy, general, very simple litigation services. So if someone is located on Main Street and this lawyer is located on Main Street and a person walks in the door and says, I need your help to file for bankruptcy. And an attorney looks at the financial record and says, yeah, you have a lot of debt, but you can't qualify for Chapter 7. You might have to consider Chapter 13 because you have a job, right? And you don't qualify under the means test, right? Let's say that's an example. Or if you qualify under the means test, but you have real estate property that you wouldn't be able to take care of in the 7, it has to be a 13. And then then you're supposed to, right, ethically, you're supposed to have a conversation with your client and say, well, let's consider what other options there are, right? What other options are there except for Chapter 13? Because Chapter 13 obviously is one of the greatest tools available for those who don't qualify for Chapter 7. But a Chapter 13 bankruptcy still has to be approved. It's costly, right? Most fees in Chapter 13 bankruptcies, last time I checked, could be anywhere between $5,000 to $7,000, and that has to be approved by the court. And also statistically, I think last time it's in our ebook. I believe that nearly 2/3 of Chapter 13 bankruptcies get dismissed because once the stay period is in place, people feel relaxed, everything is great, and then they stop making payments, and the bankruptcy is immediately dismissed. Well, they've already paid the lawyer the money, right? So an ethical lawyer will say, here's why Chapter 13 might be great for you, right? But you could also maybe potentially also try to settle your debt with creditors, and especially unsecured debt. By the way, an attorney also regularly settles secured debt. I mean, that's what loan modification attorneys do. I mean, they make great business, but that's a little bit outside. That's the secured debt part. So if you focus on the unsecured debt, and the lawyer says, well, let me try to see if I could call, as an example, Chase, American Express, B of A, Wells Fargo, and I'll try to negotiate the debt. Well, can they take upfront fees? Because it's technically providing bona fide legal services, but it's not really clear because on one hand, it's not really a program. They're not creating a program, but it's risky, right? It's risky. I mean, I could make an argument that if you do it from time to time, it's very difficult for a regulatory agency or for plaintiff attorney to say that you violated TSR just because you did one or two or three, a handful of cases. But if you do it quite regularly, it could get kind of dicey. And you have to look at the totality of circumstances to see whether or not it is a bona fide legal service. And, just shows to you how the very awkward drafting of the TSR as it pertains to attorneys could create a lot of issues. Okay. Let's move on to the next slide. I think we've kind of harped on the bona fide and the exemption a little bit. Look, this is directly taken from the FTC guidance for attorneys. This is directly. It's illegal to charge upfront fees. And they go on to say you can't collect upfront fees from customers before you've settled or otherwise resolved the consumer's debts. By the way, this is not just for businesses. It's generally for attorneys as well. Okay, let's move on. Then we're going to just elaborating a little bit more on the advanced fee ban, right? Which also applies to attorneys, right? As long as it's applicable to them, right? Or is it, right? Kind of the question. The advanced fee ban provision now explicitly set forth 3 conditions before a telemarketer or seller may charge a fee. Consumer must execute a debt relief agreement. I mean, that's obvious, right? 2, the consumer must make at least 1 payment pursuant to that agreement. And 3, the fee must be proportional either to the fee charged for the entire debt relief service or a percentage of savings. This obviously applies to everybody, but this also applies to attorneys, right? Because if you put them into some kind of a plan, a payment plan, because if you imagine that whether we're looking at the bankruptcy attorney saying, hey, maybe you should consider a debt reduction plan and try to settle the debt, or a matrimonial lawyer, right? Jessica and I were kind of like playing a hypothetical, right? She represents a husband in divorce, and I represent the wife in divorce, no kids, but they have a lot of unsecured debt. Both are professionals. And what typically matrimonial lawyers do is they want to try to get rid of the debt because they would want to split up the property without any type of debt. Because debt is what usually matrimonial proceedings would kind of linger on and complicate the process. And so, what stops a matrimonial lawyer to say to the other matrimonial lawyer, hey, listen, to make things easier for both of our clients, why don't we both split up the credit cards because they joint credit cards and try to settle the debt, right? I mean, I can't imagine matrimonial lawyers are going to want to also put their clients into bankruptcy because then they wouldn't be able to collect their fees. So obviously that settlement is widely used matrimonial lawyers. I mean, I think smart matrimonial lawyers would do it all the time. Again, do they have to be mindful? And when you do matrimonial, when they settle it, I can't imagine the husband and wife in that occasion would have a lump sum payment. Usually it's a plan. It's 99% it's a plan. Otherwise, they wouldn't be in the first position, with all this debt in the first place. I mean, the bottom line is there's always some kind of a plan when it comes to debt reduction or bankruptcy, pretty much, except for Chapter 7. Okay, let's continue. Even if attorneys engage in telemarketing, right, which we already said telemarketing is kind of very broad definition as defined in TSR, it's common for the attorney to meet with prospective clients in person before agreeing to represent them. These attorneys would not be covered by the TSR, right? That's the face-to-face exemption we talked about. So I do think it's a little bit comical in 2010 for a federal agency to draw a conclusion, right? Because it's kind of a conclusion here that it's common for the attorney to meet with prospective clients. I mean, I was already in practice in 2010. I could tell you that while many consumer lawyers typically will meet, actually they don't even meet. It's usually their staff that meets, right? It's usually the paraprofessionals. So is it the attorneys that should be meeting, or does it apply to paraprofessionals? And the reality is post-COVID, right? Everything, I should say everything, a lot of legal services these days being provided online. I know many consumer attorneys who, may meet with clients or prospective clients from time to time, but many work from home. I mean, unless you have to go to a hearing, if you're bankruptcy to a 341 hearing, or if you're a commercial litigator, you are doing a lot of things from home. Let's not kid ourselves, right? I understand people are going back to the office, but the profession is going to change. So in 12 years later, I don't know if the FTC would take the same position about face-to-face. So the question is, would this look any different in 2022 than it did in 2010, right? And perhaps should the face-to-face exemption be potentially expanded? And obviously, it's not that easy to expand it on the federal level, but we are living in a very different world today. Okay. Now, another thing that was also interesting as we're looking into this, the TSR generally exempts inbound calls placed by consumers in response to direct mail or general media advertising. It's right there and then, right? So if you read that on itself, you probably say, "Oh, I'm good. Hey, I only do inbound calls. I don't do outbound calls. By the way, attorneys can't do outbound calls. I don't know if you know that, unless someone is a client, right? Or unless they're returning to somebody's call. But generally, our professional responsibility rules prohibit us making outbound calls. We can't go and solicit clients, unless you're obviously a fan of Better Call Saul and you see Saul Goodman going out there and trying to pitch his services. But in reality, if you're an ethical attorney, you can't go out there and pitch services. So wait a second. So Felix, Jessica, so basically we're good. We could take upfront fees as long as the inbound calls are placed by consumers in response to direct mail and media advertisement. So we're good, right? We're good. We don't need to worry about the TSR restrictions. Not so fast. Wish it was. Because then the TSR goes on to say the rule provision will prohibit debt relief service providers. By the way, debt relief service providers, it also includes, technically, could also include bankruptcy lawyers. It's kind of interesting, but that's a different conversation because bankruptcy lawyers are supposed to put together a disclaimer there debt relief companies. So debt relief service providers from collecting a fee for service until debt has been settled, require certain disclosures, prohibit specific misrepresentations. And number 4, which is how to extend TSR coverage to include inbound calls made to debt relief companies in response to general media advertisements. So wait a second, right before you said, I just accidentally went to the next slide, but right before it says TSR doesn't apply, but yes, it does. Right, and that's kind of the confusion that TSR regularly creates for attorneys. Hey, it doesn't just create for attorneys who are practicing debt settlement. It creates questions. I get calls sometimes from attorneys who just happen to do this in matrimonial cases or happen to be a bankruptcy lawyer and, hey, I need to do this, but I came across TSR. Let's take it further. How many attorneys out there who have nothing to do with debt settlement, who from time to time perform debt settlement services, have absolutely no idea TSR exists? Finally, I think for those of you who are listening, you would appreciate their lawyers, right? You took the bar, you follow your CLA requirements, you pay your dues. Where are the bars with all this? Why did the bar associations in all 50 states, and I don't mean just on the state level, county level, where are the bars to say, hold on a second, we regulate what attorneys can and cannot charge? We have specific rules. Why would we have a body of law that nobody knows about that potentially could limit one's ability to charge fees how they're regularly charged by sending out invoices, right? It's like, have you ever been to a doctor who says, hey, I'm not going to be able to charge you a fee until you have a successive surgery. Hey, if I get rid of that cancer, then I could charge you a fee. But if I can't get rid of that cancer, I'm prohibited by some federal rule to charge you. That's exactly the kind of stupidity that, in my professional opinion, exists in this space. And this is where TSR really dropped the ball. It should have been more clear. It had to be more clear. It's not clear, creates a lot of ambiguity. Now I'm going to turn it over to Jessica, who will take it from here on ethical consideration for attorneys.
Thank you, Felix. So to carry over what Felix has been saying about the gray areas with respect to the TSR and attorneys, not only is it unclear what exactly is a bona fide practice of law, But there are also many of these ethical considerations that attorneys are uh, professionally under um, professionally required to abide by under their license. Many attorneys, whether they're practicing within the debt settlement space or outside of the debt settlement space, need to be aware of the additional ethical requirements that are set in place by the bars where they're licensed. And here we have some examples in addition to the TSR restrictions on charging upfront fees, which apply to attorneys no matter where or how they're practicing law. These are simply some examples of ethical considerations, and surely not an exhaustive list of all the professional responsibilities of an attorney. But here we have some of the key examples like fee splitting. There's the reasonableness of the fee. There are requirements regarding the trust account and the location of even advanced fees, and there's conflicts of interest considerations and outsourcing cases. And I'm just going to go into each of these or some of these in the following slides. So these are taken from the following few slides are taken from the model rules of ethics and are not the actual rules governed by the individual state bars. But that said, right here, the Rule 1.5 fees of the model rules of ethics. This is attorneys, whether or not practicing within the debt settlement space, must charge a reasonable fee for services. And there are these factors, which I won't list, to consider when determining whether a particular fee is reasonable. And the rule applies even to attorneys who are practicing within the debt settlement space.
So
And
are
I'll,
you saying, Jessica, sorry to interrupt you, but are you
yeah.
basically saying that attorneys that practice in the debt settlement space need to worry not only about the TSR, but also about Rule 1.5 of their respective state?
Oh, yes, for sure. That's exactly what I'm saying. There's these overlapping rules where the TSR could be impeding on these ethical rules and obligations that attorneys are already obligated to abide by under their respective states where they're licensed. Yeah.
Thank you.
And then the next slide. Yes. So this is professional. This is fee splitting. Okay, so a lawyer or a law firm shall not share legal fees with another non-lawyer, with some exceptions. So unless the limited exceptions exist, which I won't get into because the point is fee splitting is not permitted. And this means that an attorney practicing within the debt settlement space should not expect to be able to give a referral fee to a debt settlement company based on the fees charged to a client. And again, this particular rule is a model rule, so not doesn't come from the specific state licensing bar, but this also has potentially overlapping implications. The conflicts of interest. So this ethical consideration, it's pretty straightforward. When representing a client, an attorney has a professional duty to ensure that there's no conflict of interest that could potentially harm the client. For example, an attorney can't represent a client against a party when the attorney has obtained some specialized knowledge from that party during prior representation of that party. This is just one to be aware of that could come into play. And the next one, so safekeeping a property. Again, this is a model rule. So the model rules of ethics state that a lawyer shall not deposit into a client trust account legal fees that have been paid in advance, or sorry, let me start over, that the lawyer shall deposit into a client trust account legal fees that have been paid in advance to be withdrawn by the lawyer only as fees are earned. So this is a rule that shows that upfront fees are permitted outside of the TSR, so long as the TSR does not apply the restriction of on upfront fees. So, however, there are additional requirements that must be met if the fees are to be charged and received by the attorney um, are are not met. This is like this just shows that we can, as attorneys, I say we because we're attorneys, we can charge upfront fees, and we need to deposit those funds into the trust account. And the TSR steps in and says you cannot charge upfront fees. So this creates an overlapping gray area, where attorneys might be more hyper focused on where to put these fees versus whether or not they can even charge the upfront fees.
Let me chime in also on this one. And if you attended the first two workshops that we had, one we had in 2019 and another one last year, obviously we didn't have one during the pandemic. This is something that I come back to every year, and I've said this in my webinars. For those of you who are practicing in the debt settlement space and you're an attorney and you put your client into a program, when the client sends in fees, if they send fees to payment processors and they send those fees to those third party payment processors because they're supposed to be independent, your fees, your attorney fees, cannot go into those payment processors. I'm going to repeat that. Your fees, according to your respective Rule 1.15, specifically say your unearned fees, right? Or your future fees. Because the argument that I've had from lawyers, well, I didn't earn those fees, but those fees are meant for you. Let me break it down. If a consumer sends a $500 payment, if a consumer sends $500 payment to a payment processor every month, out of that $500, $100, as an example, will be future fees paid to an attorney. While the attorney hasn't earned those fees, it's still allocated to an attorney. It is still allocated to attorney. Of course, then you're going to say, but Felix, wait a second. What if this specific client cancels? Correct. Clients cancel relationship with attorneys all the time. They do. And if the money goes into unearned fees or advance fees, go into IOLTA account, attorney's obligated to return it. There's one thing that every bar is not going to mess around, escrow accounts. Lawyers get disbarred for violating IOLTA rules. Yes, they do. So I'm reminding those who are your attorneys, if you're not collecting your fees, your future fees that haven't been earned yet, but are really meant for you into IOLA accounts, or in New York, we call them IOLA accounts. Everything in New York is different, unfortunately, but IOLTA accounts everywhere else, you are potentially violating Rule 1.15 and you could get in trouble. Okay. Thank you. Jessica, go ahead.
Okay, no, that's a great point, Felix, and that brings me to my next slide. I'm giving an example of an actual state rule, and it's the rule governing trust accounts. Because, as some of you may know, I'm licensed to practice law in Florida. So the Florida bar governs my professional responsibility requirements. And one such ethical requirement, which we just briefly mentioned as a model rule, is the rule governing the nature of money entrusted to an attorney. So as you can see, the rule here is similar to the model rule in Florida. All funds, including advances for fees, costs, and expenses, must be kept in a separate federally insured bank, credit union, or savings and loan association account maintained in the state where the lawyer's office is situated, or elsewhere with the consent of the client or third person and clearly labeled and designated as a trust account. And then there's an exception. Um, but this is an actual rule. I had to learn these rules like the back of my hand and take a rigorous test on them before becoming licensed in Florida. These state rules are no joke. They're serious requirements, and every attorney practicing in Florida must abide by these rules, regardless of whether they're practicing within the debt settlement space or not. We can move on to the next slide. This is just further like a comment on the rule. Money or other property entrusted to a lawyer for a specific purpose, including advances for fees, costs, and expenses, is held in trust and must be applied only to that purpose. So these are comments that are made on the actual rule itself. So these aren't binding, but they explain the rule, sort of like the FTC will explain the TSR rules. On the next slide, so this is an ethics opinion, and this slide is just to show the seriousness of the rules and that, like the TSR has guidance and commentary on the rule, the professional responsibility rules here in Florida are no different. So this advisory opinion has to do with the trust fund rules. Okay, so this brings us back to sort of like a recap of what all we've discussed up to this point. Felix, I don't know if you'd like to jump in to summarize some of the issues you've been discussing with the gray area surrounding attorneys who don't necessarily practice within the debt settlement space.
Yeah,
Um,
absolutely. I mean, I think, but ultimately, what this is if you're practicing within the debt settlement space, you obviously need to be mindful of TSR. You can't have willful ignorance. You also need to be mindful of the ethics rules of your respective state, the professional conduct rules. However, if you're not practicing in this space, but you do from time to time um, provide services subject to the very ambiguous and unclear definitions, as we discussed earlier in this presentation, if you're a bankruptcy lawyer, family or family law attorneys, matrimonial law attorneys, commercial litigators, and commercial debt restructure attorneys, you should keep in the back of your mind to see whether or not those upfront fees apply to you. Now, I'll give you my opinion. I don't mind giving my opinion. This does not construe legal advice. I don't think the TSR was meant to apply to anybody outside of doing debt settlement or credit repair, period. I just don't think it did. That would be kind of silly, right? I don't think that the drafters of the should the TSR drafters, should the FTC have done a better job laying out the four corners, the meets and bounds of the telemarketing sales rules? Absolutely. And I don't think it was done. With that in mind, if you're a commercial bankruptcy lawyer, or commercial debt restructuring lawyer, you absolutely could take upfront fees. And I think if you're worrying about TSR, well, you should probably litigate if regulator wants to make an issue. That's right. I mean, commercial bankruptcy lawyers do it all the time. If you go to Google News, right? If you go to Google News. You could do it as an experiment, and I've done it with Jessica. And you type in the word debt settlement. What you actually see, other than articles about debt settlement, you actually see debt settlements that are done in the corporate reorganization world, right? So corporate bankruptcy lawyers, a lot of times will say, hey, before going down this Chapter 11 path, if this is obviously a Chapter 11 reorganization, why don't we try to restructure these debts, secure debts? And so they restructure them and they send them invoices before the work was performed. Therefore, it's an upfront fee. So I do think, in my professional opinion, that the TSR was never meant to apply to these. However, the purpose of what Jessica and I trying to do here, to say the poor drafting and the lack of clarity creates this kind of vacuum of issues that unfortunately are still unanswered. And hopefully you're beginning to understand how difficult it is to help lawyers navigate this environment, because while they need to be mindful of TSR, it's not that easy if you are also doing you're practicing in other areas of law. Did I miss anything, Jessica?
no, I think you summarized it really well.
Okay, so
So these are cases, it's just going to be one case showing the prohibited attorney's fees. I wanted to go into this Morgan Jackson case. It's one case I just wanted to point out just to show where the CFPB has sued attorneys with allegations of charging unlawful upfront fees with respect to debt settlement services. So the case is very complex, so we won't go into the full details of the allegations. The gist of this case, for purposes of this presentation, are the allegations that the attorneys used what is colloquially, if I'm saying that correctly, known as the attorney model of debt relief services. So under the attorney model, consumers contracted directly with attorneys affiliated with Morgan Jackson for the provision of debt relief services and paid the attorneys upfront fees in advance of any debt being settled. We can go to the next slide. Okay, and this slide just shows, to go back to inbound and outbound calls, that the allegations in this case were that consumers would respond to Morgan Jackson's advertising and actually call in the toll-free number listed to inquire about the advertised debt relief services. These are just facts of the case. You can go to the next slide. Okay, so here we can see allegations that Morgan Jackson received the upfront fees for the offered debt settlement services. It says that consumers made monthly payments minus the $50 monthly administrative fee or other outstanding fees. We can go to the next slide. Okay, so at the end of the case, these are the civil minutes that is taken from the final judgment in this case, where it found that Morgan Jackson collected unlawful upfront fees. Even worse, so I do want to point out this part. Even worse, the attorneys took measures designed to ensure that the affected consumers would be confused, if not outright misled, about their rights in the wake of Morgan Jackson's shutdown. That's the part we're not really going to go into. I just wanted to point it out because these attorneys are ultimately found in contempt. If you can go to the next slide. Okay, so the CFPB was able to prove by clear and convincing evidence that despite the knowledge of the injunction that was in place, the attorneys in the case intentionally stepped into the shoes of Morgan Jackson to collect the unlawful upfront fees. And unfortunately, as a result, next slide, the attorneys were found in contempt of court and ordered to refund the monies received. And they were also ordered to pay $10,000 per day for every day that they continued to violate the injunction in the case. And the next slide, yeah, this talks about restitution in the final order. So Hansen, who is a forensic accountant at CFPB, he defined upfront fees to include both the bankruptcy planning and preparation fee in this case, as well as certain monthly maintenance fees that we saw in a previous slide. In the next slide, talks more about the restitution. So the full measure of the restitution encompasses both the unlawful upfront fees charged as well as any subsequent non-upfront fees that the consumers paid. And so we're getting to the amounts that everyone wants to know. It's ordered. The restitution was over $132 million as restitution, and the civil penalty was $40 million. So it just shows the gravity of the damages that can be ordered to be paid whenever you violate the TSR.
Thank you, Jessica.
Yeah.
So we'd like to add in this webinar by just listing the list of our services. And once again, making a final pitch 2 weeks away. We hope to see you all in person. For those of you who don't subscribe, please subscribe to debtreliefwatch.com. You'll subscribe to a free news alerts and any announcement about our future webinars. And we are very grateful for your participation. We look forward to seeing you at our future webinars and hope to see you in a couple of weeks in Costa Mesa. Thank you.
Thanks, everyone. Thanks, Felix.